All right, in part two of this two-part series about two of the biggest verdicts in New York State, we're going to talk about a $117 million verdict. What it took to get this verdict, what it took to handle the jury, the big mistakes made by the other side. And we're going to talk about with Steve Williamson, who's an amazing personal injury attorney in New York City, what he's learned over the years. That's the big turnaround for him, the big shift in how he prepares for these trials that really helps him to win these types of cases. It's an amazing True Law Story series. If you haven't watched the first one, make sure to watch the first one because we really are going to talk a lot about juries and the jury system and insurance companies and all these other things about how people are being led to think in a different way. But of course, this is brought to you by videocasestory.com. One of the best ways to grow your business or grow your law firm is through your client stories. And of course, one of the best ways to learn about that is go to videocasestory.com and you can pick up a copy of Video Testimonials That Land the Big Fish, the #1 Amazon bestseller on using video storytelling on YouTube to land new clients. All right, let's get started.
$10 million is a lot of money, but $117 million for a pedestrian accident case, that seems like a lot of money. He says, what was different? What took that case to even that higher level?
Again, no two cases are the same. These were two very different kinds of cases. What I can say is one commonality is that in both of those cases, the defense really tried to blame the plaintiff for almost everything in the case without the goods, without the evidence. And that didn't work for them in either one of those scenarios. We talked about how in the $10 million case, they blamed her for the incident and they blamed her age for the problems we said came from the incident. This other case that had the $117 million verdict, in that case, they blamed the plaintiff for a lot of stuff that he wasn't responsible for. They refused to acknowledge the righteousness of his claims, and they essentially said that he was faking, that he was malingering and exaggerating, and they just didn't have the goods. So that's quite an accusation to make towards someone, that they would not only exaggerate or put forward something that wasn't true in terms of an accident and an injury, but then to say that they have perpetrated what in essence would be a fraud over years of a litigation and then up through trial in a court of law. That's an extraordinary accusation. And it seems to me that for the defense, just like on the plaintiff's side, you can't make an accusation. You certainly can't make a significant or extraordinary accusation unless you've got the goods to back it up. And in this instance, they didn't have the goods. This was a righteous case. The evidence was on our side, and they refused to accept responsibility, refused to acknowledge the legitimacy of the case, and they just didn't want to take account for what had happened or step in and make my client whole. And so they had a dilemma. They had to find a way to defend the case. And in their mind, the way to defend the case was to call the guy a liar. It was the furthest thing from the truth. The furthest thing from the truth. And the commonality between those two cases is the defense, I think, not only got it wrong, but was putting forward something to the jury that the jury just wasn't going to buy. You know, these are smart, savvy New Yorkers who serve on juries in Queens, in Brooklyn, in the Bronx, in Manhattan. And you got to sell it to them straight. You got to give it to them in a real way. And when they see a circumstance where negligence has happened, someone has gotten hurt, and the injury has really impacted or ruined someone's life, and then the wrongdoer refuses to take responsibility and instead plays the blame game and drags someone through years of litigation and weeks of trial, it doesn't make them feel warm and fuzzy inside. It's upsetting. And that's not to say that they're reacting with their verdict or their decision with passion or upset, but they're calling the case as they see it. And again, it goes back to the human suffering. When you have a righteous person who's lived a good life, they've worked hard, played by the rules, they've done everything right, and then through no fault of their own, all of that is taken away from them, and they've been made to suffer for years and years, and the evidence is clear that the injuries are permanent. They're going to continue suffering for long into the future. Jurors recognize that's worth a lot. They recognize that's worth a lot. And I will say that when a verdict of that size comes back, you'll hear folks on the defense side, you'll hear people from the insurance industry say, look, here's another example of a runaway jury and an extreme result that has no basis in reality. It's another example of how the jury system is running amok, and juries can't be trusted, and we need a different and new system. And I would argue none of that's correct. The opposite is true. This is the tort system at its best. The tort system goes back to the beginning of our country. This is a pillar and foundation of American law and American society from the beginning of our country. It predates our country back to England. But from the beginning up through now, the tort system is not just designed to give individual people who have been wronged an avenue for relief. It's meant to provide a mechanism for adhering to creating standards of safety to make the community safer. And these types of verdicts send a strong signal that wrongdoing and a refusal to take responsibility not going to be tolerated.
And how do you think a verdict like this will affect future cases?
I can't say for sure, but I think when the defense industry and the insurance companies see verdicts like this, hopefully it gives them pause, that they have to evaluate their cases in a meaningful way. They can't look at things in a blanket way, that we're going to defend all these claims and it's just going to be about the bottom line and saving money and winning at all costs. We're going to look at these cases individually. We're going to pick out the ones that are legit, that are righteous, and we're going to do everything in our power to try and give the person closure as quickly as we can, a fair result for all sides, and full justice for the injured party in a way that doesn't make them wait through years of delay and go through the stresses of litigation and trial. Hopefully it sends a signal that's the right thing to do, and it's also in the interest of the insurance company to do that, because if they don't look at these cases that are legit and righteous, that should be resolved, and resolve them before trial, they're going to end up losing. And if they don't have a valid defense and they come forward with this gamesmanship of blaming the plaintiff, either for the incident or the injuries, it's not going to end well. They're better off for their own self-interest, not just the benefit of the injured party, but for their own self-interest to reach a fair resolution earlier.
And so both these cases you talk about, the commonality of the defense knowing that they must know, right, that they really don't have any evidence, or are they fooling themselves? Is it because we've talked in criminal cases where there's a prosecution, and once they go down that prosecution path, they really can't turn around. It's really difficult to turn around and say, hey, we did this wrong. Is that what's going on? Because obviously it takes work, it takes money, it takes effort. Is it just legal departments going, hey, we want to prove our worth? What pushes these cases forward? Because if it's that obvious to juries and you bring that out, do you feel like what's in the mind of the defense?
It's hard for me to say for certain, but I think that there is an analogy to be made to what you said with prosecutor and the criminal system, because it takes courage to be a prosecutor with a heart. It takes courage to say, I've gone partially down this road and we're wrong. This was not what we thought it was. And we're not going to prosecute this guy because we don't have the goods, or we may not be able to prove this beyond a reasonable doubt. Maybe he didn't do the crime. That's hard because you're not saving face, and there's a fear of being criticized or looking weak. But the truth of the matter is the strength comes in acknowledging when you're wrong. And I think that's an important lesson for life. It's something I think a lot of us try and impart to our children. which is it's not about being right just for the sake of being right. It's about being just. And we all make mistakes and we go down roads, and if part of the way down the road the facts change, we have to change with those facts. And I think on the civil side, part of it is you have people who have, over years have developed a bunker mentality. They've become so partisan in looking at these lawsuits from one side and through a filter of negativity that sometimes they miss the forest for the trees. And they just make all of these assumptions at the that cloud their judgment and prevent them from seeing the nuances and the legitimacy in a case. And I think sometimes there are competing voices on the defense side. I've seen circumstances where the lawyers are arguing to their own client, the insurance company, that this is not going to go well for us, that this is a case that should be settled. And the insurance company is just dug in. I think there is a lot of that bureaucratic inertia. When a case early on gets written up in a certain way, it becomes stuck and hard to move it off that initial assessment, even if over time as the case develops, and certainly as the case gets nearer into trial, a different interpretation is warranted. And again, every case is different. I've seen many instances, to the credit of the defense lawyers and the insurance companies involved, where they recognize that the right thing to do is to resolve the case, or they recognize that they can't win and that the case should be resolved and the plaintiff should be given closure. But there are many instances where they really get it wrong and they get stuck. And I think that the zeal of wanting to win and the financial component of wanting to save money becomes paramount, and the facts of the case and what's right gets lost in the mix, unfortunately.
And so from your standpoint, obviously you don't know if they're going to do that, so you have to prepare constantly for trial. And one thing I know from interviewing hundreds upon hundreds of attorneys is the best ones always talk about how much work they put into preparation. And when you talk about speaking to a jury and talking to the jury and getting ready to, and that's not something that just happens that day. It's months and possibly years of preparation. What were the keys to preparing to tell these stories to the juries to win these types of cases?
It's certainly not an easy job, and there's a lot of work that goes into it. And even when you've been doing it for years and decades, that enormous amount of work is required to be ready for trial and to be in a position to present in court in a way that's effective and to win. I think one of the components that's important is really getting to know your client well. And that's not just their story from the time the incident happened and when they got hurt and how they've been impacted, but going back much further to their early and their whole life. Because the way I look at it is the story of the case is the story of the incident and the injury and the impacts. But you can't tell that story without a backdrop. And the backdrop is the story of who the person is and their life overall. And so I think you have to spend the extra time to really get to know your client so that you understand what that backstory is. And you can understand how the story of the incident and the injury and the impacts intersects with that backstory. And then the other thing that I think is super important is being able to tell the story of what the client has lost. We sometimes get caught up in talking about everything that's happened after the incident, all of the treatment and surgery and disability. But what the case is also really about is what the person has lost. And that means you have to go back before, and you have to uncover the story of how they were living their life before they got hurt. And they're not the only ones who tell that story. You have to speak to family members, you have to speak to co-workers, sometimes all different sorts of people. Every person's circumstance is different. But you want to identify the people in the person's life who are in the best position to tell the story of who they were and what they did before, because that's the only way to tell them tell the story to the jury of what the person has lost. And then, the other thing I think goes into it and takes an enormous amount of work is anticipating what the defense is going to do before the trial happens. Part of the job of a good plaintiff's trial lawyer is to put himself or herself in the shoes of the defendant and say, okay, what are the weaknesses in my case? What are the issues in my case? What are they going to make hay about? If you look at your case with rose-colored glasses and just look at the positives, or pretend that the weaknesses are not there or not as bad as perhaps they are, you're gonna get caught short in the courtroom because you can be almost guaranteed in every case that the defense is going to seek to exploit all of those issues. And to be clear, a case can be completely righteous and completely true and deserving of full justice, but also have weaknesses and issues that the defense can make an issue about. That's how life is. If you think about any circumstance in life, you may be in a true situation or a real story, but there's issues, there's give and take. And in the hands of an experienced defense lawyer, those can be exploited, they can be mischaracterized. And so you have to be aware of that in advance and prepared to address it.
And you've been doing this for 20 years, and obviously you've evolved and changed. What do you think are the one or two things that have changed about how you would address all these things, or maybe even tactics that have changed that you wouldn't have done 3-4 years into being a personal injury attorney, a plaintiff's personal injury attorney, that you do now? Or is there like one single tactic that you changed? I'm just trying to figure out what's your secret sauce, what I'm trying to find out.
I don't know that there's a specific secret sauce or one specific thing, but just to piggyback on the last answer, one thing that I think that I've done more of in recent years is being honest with myself about what the issues are in the case that are not good for me. And I think when I was a younger lawyer, and I think a lot of lawyers are either subconsciously or unconsciously susceptible to this, is you want to win the case so badly. You want the jury to like you and trust you and like the case. And so there is this internal reluctance or disincentive to talk about your weaknesses fully or at the outset, because you're afraid that the jury's mind is going to close to the case, or they're not going to be open to you or the other, the positives in the case. And that's really the wrong way to approach it. You have to fight against that inclination, because as I said before, everything is going to come out at the trial, the good and the bad, and the defense is certainly going to exploit whatever the weaknesses are in the case. So one of the things I think I'm doing a better job of now compared to when I was a younger lawyer is determining what those issues are and dealing with them frontally and dealing with them fully and dealing with them early. And I think that has a couple of positive benefits. One, you're stealing the thunder of the defense. You're taking their issue away from them. You're neutralizing whatever the argument they're going to make because you're saying it first and you're acknowledging it. You have an opportunity, to the extent that it can be done, to put the proper context on whatever the issue is. Because if you don't bring something up because you're afraid of it, and the defense brings it up for the first time, they're going to bring it up for that first time with their spin and their context on it. And first impressions, as we know, are important. And so I think you do yourself a disservice by allowing the defense to bring something up that's important to the case for the first time without you having mentioned it first with their spin and their context on it. And then the other benefit, which I think is equally important, is you gain credibility with the jury. And this goes back to what I was saying before. If you stand in front of the jury from the beginning and say, this is the whole case, these are the issues, some of which I'm worried about because they may be weak points for me, you generate a certain credibility with the jury because you're acknowledging those issues from the outset, as opposed to the opposite, where you don't mention them and then they hear it for the first time from the defense and they're like, why didn't Mr. Williamson tell me that? It accentuates the weakness. The omission makes it bigger, and the jury might think he's trying to hide that from us, as opposed to getting the credibility that comes with acknowledging something. It's like anything else in life. If you're in a situation with someone and right from the outset they say, look, this is a circumstance, I think we should do X. There are some issues and some problems, and here's what they are, and this is how I contributed to making the problem. You're like, wow, this person's being completely forthright with me. They're laying their cards on the table, and it's not all good, but that's life, and I'm going to trust them. And I think that's the way we have to approach it with juries. And I think we were talking earlier about the contrast with the defense. The same thing goes for the defense. If there's strengths in the plaintiff's case and they refuse to acknowledge them, if there's reasons why they should, accountable in one way or another, if they fail to acknowledge that, they just play the blame game and evade responsibility, it doesn't score them credibility points with the jury.
And it seems so simple, but it's one of those tough things to do, I'm sure, because you have this big case, all this money on the line, and it's like, I'm going to expose all my vulnerabilities up front. That's brave. It's tough, I'm sure.
It's scary.
Yeah.
It's the same reason why people walk into professional situations, or kids will walk into the principal's office and they don't want to lay it all out on the table because they're afraid. But the reality is that your coworkers, your boss, the principal, they're going to figure it out. They're smart. They got common sense. They're going to put the pieces of the puzzle together. And if they hear it from you first at the outset, they're going to look at it with more of an open mind, and they're going to look at you as a credible source of information. And that goes back to what I was saying before, that the jurors are looking across the courtroom. Who's the person in this room that I can trust? Is it the plaintiff's attorney? Is it the defense lawyer? Is it the judge? Is it the court officer? Who's the person who's going to level with me? You want to be that guy. And there's much more power in being that guy than, trying to make everything perfect.
In the other aspect, because we talked about we talked about how important juries are, but I think a lot of people don't understand. Like, I know when anyone talks about jury duty, right? It's like, oh God, I got jury duty. How do you think this should affect how we perceive jury duty? Because I know everyone talks about just how to get out of it, right?
Yeah, I think we're going to have a hard time with that because it's got such a bad rap. But what I can say is 95% of the time when I speak to juries after the case is over, because in New York, once the case is finished, whether it settles during trial or there's a jury verdict, once it's fully done, the jurors are free to talk to the lawyers. And I always take an opportunity to speak to them because we can really learn from what they tell me, what they liked, what they didn't like, what they believed, what they didn't believe. But almost always they will say, wow, this was much better than I thought it was going to be. It was a much more interesting and rewarding and fulfilling experience than I thought. And nobody feels that way until they've served on a jury because it's got such a bad rap, and everybody just talks about it, as you said, trying to get out of it. And sometimes we have jurors and we can invite them to serve and they're willing. Other times we bring them onto panels reluctantly, but almost always they feel it was a much more dynamic and rewarding experience than they initially thought. And oftentimes it's a moving experience and it's an emotional experience. And I've heard stories where jurors have stayed in touch with other jurors and remained in contact and become friends because they have this shared commonality. And if you've got a serious case, the jury is not only doing justice, but really helping a family or helping someone who has suffered a terrible injury. They have a real sense of having done something meaningful and important. And I think by the end of the trial, they understand that there's nobody else. If it's not them, there's nobody else. And that's something that we tell people at the outset, and it falls on deaf ears. But the reality is that when you've got a dispute, a civil dispute, when you've got someone who's become disabled because of recklessness or negligence, and the insurance companies or the corporations on the other side won't play fair, won't resolve the case, the only avenue not only for closure, but for justice and giving the person what they need to move on with their life and be secure and safe for the rest of their life, is a group of people who are willing to serve on the jury, to give their time. And I think it gives jurors a different perspective. They recognize that there's a larger force at work, that they, in that individual case, are one piece of a much larger puzzle that enforces safety standards across our society.
Yeah. And I think that's great. It's an important thing to understand, because I think when I talk about it, I talk to so many personal injury attorneys that most people look at it as from the flip side, as it's jury duty is a waste of time, and that in personal injury cases are just about getting someone a little bit of money for their car accident or trying to get too much money. Not, like you said, enforcing safety standards, not making sure the insurance companies pay the money.
Listen, it's no coincidence. This is deliberate. Is $10 million too much? Is $117 million over the top? One of the things that I think gets lost in the mix is that when a trial ends, whether it's by a jury verdict or by a settlement, it's over forever. The person, whether the plaintiff is 26 years old or 36 or 46 or 56, when the case finishes, the case is over for forever. They can never come back to that court or any other court and reopen their case. They can never call their lawyer 5-10 years down the road and say, my injury has gotten worse, or I thought I could go back to work, but now I can't, or I've got these new complications, or I'm going to have a surgery that wasn't anticipated, or I've got these other repercussions that we didn't know about, but it all flows from the original injury. They call their lawyers with those issues or those complaints later. The best lawyer in the world can only say one thing, which is the case is over, and it's over. It ended with finality. And when a jury sits and listens to a case, that is the only jury that person's going to have for a lifetime. That is the plaintiff's forever jury. And so if the plaintiff is suffering with permanent injuries or has been caused to be permanently disabled, and they're a young person or a person in middle age and they've got a lot of years and a lot of working years ahead of them, whatever that case resolution is has to provide for those injuries into the future for the rest of the person's life. So it's not by happenstance that people think this way. And the great thing about serving on a jury is it disabuses you of those false notions. You see the process for what it really is. And that's part of what people tell us when they finish their service. They say, I have a whole different perspective now, not just on jury service, but on the civil justice system. All of those inaccuracies wash away because they're not real. And people who go through the process, they see what it's really about. And it's just like any other stereotype that's out there. It's really usually almost entirely false. And when you get confronted with the person or the thing up close, you're like, wow, the stereotype has nothing to do with reality.
No, yeah, no, and that's great. And it's really, I think it opens eyes, and I talk about it because most people don't realize this. They don't, and all that. Even if you do get in an accident, that they're afraid to sue because they're like, I'm not a type of person that sues because the insurance company has told them that only bad people sue. It's
exactly, as opposed to recognizing that it's one of the pillars of our justice system that has existed since the dawn of the Republic, and it's one of the things that keeps us all safe as consumers, as patients, as drivers. This is what keeps us safe. It's not the criminal law, it's not the regulatory agencies, it's not the police. It's a system that sends a message that if you don't act reasonably, and you don't think about your neighbor, and you don't think about the people who are on the road with you, if you don't think about the people you're selling products to in a way that puts safety first, you're going to be held accountable.
Yep. Yeah. And so,
and I think when we hear about big numbers, whether it's a settlement or a jury verdict, gets sensationalized in the press, people don't think about the fact that this is money that the person is going to have to utilize for the rest of their life. When you go shopping, I'll put it in simple terms. When you go shopping for your family for a week, you've got kids, but you could spend easily over $200 on a big shop, right, at the supermarket for a week, 2 weeks of food, right?
Yeah, right.
Okay, so let's say it's a couple $100 for a week. What if I said to you next time you go shopping, you have to shop for your family for the next 35 years.
Wow.
You have to buy everything that you're going to need. And we'll forget about medical supplies, we'll forget about medication and insurances and all the rest. Let's just talk about groceries. We need groceries for the next 35 years. And think about what that shop is like and what that bill would be. And, people may roll their eyes, but if you're a hardworking guy who's got a family to support, and then through no fault of your own, you can't work anymore, you still have to put food on the table.
Mm-hmm.
Someone still has to shop, otherwise the cupboard's going to be bare. And so we have to provide for all of those future years. And when you think about shopping for 35 years and what that entails and what it costs, when you think about medical costs for the next 35 years, when you talk about an injury that causes someone to suffer every day, and it's 365 days for 35 years going forward, and all of that is righteous and real because you've sat through 3 weeks of trial with your fellow jurors, and with your common sense and your good judgment, it's on the level. Those big numbers, they don't seem so big anymore. They seem reasonable. And that's a story that doesn't get told. And that all flows from the concept that when the verdict comes in, or when we reach a settlement, and we're talking about lifelong or permanent injuries and losses and damages, we have to account for all of that future and all of the losses over all of that time.
Yeah. And I mean, you say buy all the groceries now, but we're not buying all the groceries. No. How much groceries going to cost in 10, 15, 20 years? I mean,
That's exactly right. That's why we bring in economists when we have lost wage claims and we have life care plans, because if you have someone with permanent injuries and they're going to have to buy medication, not just now, but in 35 years, an aspirin that costs $1 today, in 35 years is going to be $2. And so you need an economist in there to look at the historical trends with inflation and the rising costs of medical care, medical supplies, and the rest.
well, Steve, this has been fascinating. It's, congratulations on 2 main cases, and thank you for your time. Tell us a little about working with you, who you work with, how to do.
I just want to say that what's most gratifying to me is knowing that the clients got the results that they deserve. There's a couple things that I think make this a difficult job. One you touched on earlier, which is it's an enormous amount of work. There's a ton of work that goes into it. One of the things is the amount of work that has to be done. But I think the other thing that is both a privilege but also takes an emotional toll is presenting and working with people who are in very difficult predicaments. And for them, everything's at stake. Their life is on the line with the case. And when the case goes to trial, the stakes couldn't be higher. And they're really looking and depending on you for everything. And so it's a big burden and it's a lot of pressure. And you don't know until the result comes in whether you're going to achieve justice for your client. And the thought of having a bad result and them not having the money that they need for their replacement income and for their medical expenses in the future, it's hard to fathom. But when the result comes that's full justice, it feels great to know that you've secured someone's future. And it's nice for lawyers to congratulate themselves over big results, but I think the true gratification comes in knowing that you've done right by your client.
Amazing. Yeah. That's fantastic. I mean, that's what everyone should for an attorney, right? It's someone who cares that much.
I think so. I think that's what makes the difference is caring and the close connection with the client.
And so working with you, obviously you work with a client. What's the best, what's the work with you? What's the process?
I like to think that one of the ways I'm different is my accessibility and the close connection that I have with my client. They always can pick up the phone and call me directly if they need to speak to me, whether it's in the evening or on a weekend. I'll take the call, or if I can't take the call because I'm with my family, I'll get back to them in short order. And I tell my clients what's most important for us, for me, and really for us, is that we have an open dialogue, that there's nothing that's in your heart or in your head that you're worried about that you're not sharing with me. Because I wear many hats. One of the hats I wear is to be fighting on your behalf against the other side and in the courtroom. But the other hat that I wear is as your counselor and to shepherd you through this process because it's difficult and you've never been through it. And while I don't have all the answers, I have the benefit of experience and I can hopefully demystify some things for you and tell you what's worth worrying about and what not to worry about. Because again, it's like for me in my life, if I'm going through a process for the first time and unfamiliar, I don't know what to expect and I'm worried about things I shouldn't be worried about. I'm not worried about what I should be worried about. And it's the same thing for the folks that we represent. You have to make the time to answer the questions and make the clients feel like there's no silly questions and make sure that they really have the proper context and understanding to appreciate what's going on.
Great. And so how do we get in touch with you?
You can go to the website. There's a phone number for the office. You can reach out to us by email. We're accessible 24/7. And we'd love to hear from you if you feel you've been harmed and you need justice.
And we'll put a link to all of that in the show notes. We'll put a link to also all the we talked about all the case information that we talked about in the show notes on YouTube. Or if you're listening to this on the podcast, just click on the image and you'll see the links to it. Steve Williamson, thank you so much for being on True Law Stories.
It's my pleasure. It was fun. Thank you so much.
And thank you for taking Steve and I on your journey. This has been Iron Garlic and True Law Stories.